Hello, everybody. For those of you I don't know, I'm Bob Levy, Chairman Emeritus of the Cato Institute, a libertarian think tank headquartered in Washington, D.C. And when I say libertarian, I'm not referring to the political party, but to libertarianism as a political philosophy devoted to private property, free markets, individual liberty, and limited government. At Cato, we don't endorse candidates or parties, and we're critical of both Democrats and Republicans, but we do have a consistent minimalist view of the proper role of government. Conservatives agree with us on some issues, like lower taxes, less spending, and fewer regulations. Liberals agree with us on other issues like civil liberties, marriage equality, and criminal justice reform. Libertarians embrace small government across the board, a government that stays out of our wallets, out of our bedrooms, and out of foreign entanglements unless our vital interests are at stake. Okay, with that background today, I'm going to address the Supreme Court, more specifically, 9 of the most important cases decided during the current term, the one that began on October 1, 2024, and ended on June 30th, 2025. Bear in mind that the court gets about 11,000 petitions for review each year, out of which 60 to 70 cases are typically decided annually. So these 9 cases are the pick of the litter. Let's set the stage with a look at the court's makeup. Currently, there are 6 justices who lean conservatives. Clarence Thomas, who has served nearly 34 years, Chief Justice John Roberts, 20 years, Samuel Alito, 19, Neil Gorsuch, 8, Brett Kavanaugh, 7, and Amy Coney Barrett, 5 years. On the liberal side are Sonia Sotomayor, who has served 16 years, Elena Kagan, 15, and the newest justice, Ketanji Brown Jackson, 3 years. Recapping the latest term, the Supreme Court issued only 56 argued and signed opinions, excluding its emergency docket. That's the smallest number since the 1930s. Roberts was most often in the majority, 95% of the time. Jackson least often, 72%. Liberal Kagan was in the majority more than conservatives, Gorsuch, Thomas, and Alito. Just 10% of the cases were split ideologically, compared to 14% from 2020 through 2024. 42% of the cases were unanimous, a little lower than recent years. Here are the top alignments. Alito and Thomas agreed 97% of the time. Jackson and Sotomayor, 94%. Roberts and Kavanaugh, 91%. There were 14 emergency orders, 11 of which favored Trump. So that brings us to the 2025 cases likely to have the greatest impact on the country. The key issues include treatment of transgenders, gun restrictions, social media, religion, reverse discrimination, abortion funding, separation of powers, and universal injunctions. Obviously, I won't be able to explore all the details, but I'll try to hit the major themes, nor do I pretend to be a strictly neutral observer, but my intent here is to summarize and not to advocate. My apologies in advance if there are a few irresistible exceptions. Let's begin with the pivotal emergency order on nationwide injunctions. Individual plaintiffs, organizations, and states convinced 3 district courts to issue nationwide preliminary injunctions that barred enforcement of Trump's January executive order ending birthright citizenship. Here's the issue. Can a single district judge issue an injunction against the executive branch that covers persons who didn't sue in multiple jurisdictions? On June the 27th, in Trump versus CASA, C-A-S-A, the Supreme Court significantly constrained district courts from issuing universal injunctions, but declined to rule on the constitutionality of Trump's executive order ending birthright citizenship. The court did, however, bar the executive order from taking effect for 30 days. Justice Barrett, for the six conservatives, stayed the three injunctions to the extent that they were broader than necessary to provide complete relief to the plaintiffs in the case. She wrote that the Judiciary Act of 1789 did not grant courts authority to issue universal injunctions, nor are those injunctions sufficiently analogous to relief available historically in the United States or under British common law. Sotomayor dissented, joined by Kagan and Jackson. She accused the majority of addressing a procedural question when important substantive issues regarding birthright citizenship should have been and could have been resolved. The dissenters were also concerned about White House gamesmanship. By not appealing his losses, President Trump could effectively force separate lawsuits by thousands of plaintiffs. In this case, the plaintiff's child will not be denied citizenship. Yes, children often move across state lines or they're born outside their parents' state of residence. But Barrett left it to lower courts to structure an injunction consistent with her ruling. Blocking executive branch actions nationwide will still be permitted in three circumstances. Number one, it's the narrowest way to adequately protect the plaintiffs in the case. Number two, by use of class actions that meet certain rules. And number three, cases that are brought under the Administrative Procedures Act, which allows judges to overturn agency rulemaking. Bottom line, here's what's likely to occur. More cases will be filed, more work for the Supreme Court, which can issue universal injunctions, and more suits by state attorneys general who, as plaintiffs, can get statewide relief. My view, some situations require national uniformity. For example, building a border wall, regulating social media content, restricting mail order access to certain products. The resolution of those issues can't be limited to particular parties or jurisdictions. I would have endorsed a slightly different solution, partly adopted by the Supremes, namely, Congress should bar a national injunction by a district court unless, first, it's needed to fully remediate an injury, or second, the government has violated clear controlling Supreme Court precedent. And third, Congress has provided an expedited appeals process. Meanwhile, Trump has been enjoined more than 100 times versus 24 for George W. Bush, 38 for Obama, 28 for Biden, although that's probably because Trump has issued so many executive orders. Among the currently outstanding nationwide injunctions are those blocking proof of citizenship to vote, a ban on DEI programs in public schools, halting nearly $2 billion in U.S. aid funds, and providing free legal counsel for more than 25,000 children who face deportation. Those injunctions must now be revised or reversed, but the underlying substantive questions will still have to be resolved. Those questions will ultimately determine whether Trump's various proposals are constitutional. In our next case, U.S. v. Scarmetti, three teenagers, their families, a doctor, and the Biden administration challenged a Tennessee statute that bars puberty blockers and hormone therapy for transgender teens. More than 20 states have similar laws, although they directly impact less than 1% of the population. In Tennessee, treatment is prohibited even if the parents want their child treated and even if medical professionals think treatment might help. The questions for the court were twofold. First, does the law discriminate in violation of the Constitution's Equal Protection Clause? Second, if there's questionable discrimination, is it based on the patient's sex? That matters because sex is a specially protected class, which would prompt more rigorous scrutiny by the courts. Of course, nearly all laws treat some people differently than others. But ordinarily, the federal government doesn't interfere when states exercise their traditional police power to regulate health and safety, particularly when it comes to children. For example, states have made it illegal for minors to purchase guns, cigarettes, or alcohol, even with parental consent. At oral argument in December, several of the conservative justices suggested, as they did in the Dobbs abortion case, that state legislatures, not federal judges, are best suited to evaluate complicated medical issues. Justice Kavanaugh put it this way: the Constitution doesn't take sides on how to resolve medical and policy arguments. So, why shouldn't courts leave those matters to the democratic process? He might have asked, but he didn't. Why shouldn't courts leave those matters up to the parents? On the question of whether Tennessee's discrimination is sex based, the state argued that men and women are treated equally. So, while there may be discrimination against transgenders or discrimination based on age, it's not based on sex. Notably, classification by transgender status or age does not trigger heightened scrutiny by the courts. Tennessee's law does not use biological sex to determine who can get treatment. In June, Chief Justice Roberts, for the court's conservative majority, upheld the Tennessee ban. He concluded that the ban is not sex-based, but simply excludes one set of treatable conditions: gender dysphoria and identity disorder. Roberts further acknowledged the fierce scientific and policy debates about the safety, efficacy, and morality of transgender treatments. But, he added, those questions should be resolved by our elected representatives and the democratic process. Paradoxically, in other cases, the rallying cry from conservatives has been parental rights without state meddling. And conservatives have usually embraced consumer choice, even for ineffective products such as herbal remedies. The litmus test has been whether the treatments are harmful. On that score, the science is unsettled, and that's one reason the court deferred to the Tennessee legislature. Still, I would argue that parental rights should control unless there's overwhelming evidence of serious harm. Even assuming that government is motivated to protect transgender children, the law is both under and over inclusive. Puberty blockers and hormones such as estrogen and testosterone are used primarily by cisgender kids. The Tennessee law is thus under-inclusive in covering only transgenders. Equally important, transgender children are heterogeneous. Some would benefit a lot from treatment with little risk. Others might have health issues that raise the risk level. The Tennessee law is thus over-inclusive in covering all trans kids without distinction. Our next case also raises LGBT culture war issues, specifically parental rights versus school curriculum. Here's where we find conservatives asserting parental control over the books their kids read, even though they would let the state override parents when it comes to what medical treatment their kids can get. In Mahmoud v. Taylor, some parents in Montgomery County, Maryland, wanted their children to opt out of instruction on gender and sexuality that goes against their religious convictions. The parents weren't seeking to eliminate the program, but merely to allow opt-out, which the county had previously permitted. Beginning in 2022, the county's elementary schools included books featuring LGBT characters in the language arts curriculum. Some Muslim, Jewish, and Christian parents objected on the ground that their kids were being denied First Amendment rights to free exercise of religion. The Court of Appeals for the Fourth Circuit ruled for the county, explaining that the parents had not shown that exposure to the storybooks was a religious violation. P.S. We, libertarians, would have resolved this by getting government out of the education business altogether. Private schools are the best way to exercise parental choice, not just for religious parents, but for the non-religious as well. Sadly, that solution wasn't in the cards. In an opinion by Alito for the six conservatives, the court held that requiring LGBT books infringed on the rights of parents to free exercise of religion. Lower courts had taken the too narrow view that only government compulsion to renounce or abandon religious beliefs would raise First Amendment concerns. Justice Sotomayor's dissent for the three liberals seemed to adopt that position as well. The books in Maryland didn't go that far, but they were moralistic, not just descriptive, and teachers were encouraged to criticize alternative views. So the court preliminarily required the school board to reinstate its notification and opt-out procedures and sent the case back to the lower court for a permanent resolution. Unlike the case involving transgender medical treatment, parental rights partly won the day with the conservative majority. Students won't have to attend classes if the books offend their religion, but parents still can't select the books that affirm their religion. Only school choice affords a full range of options. Next, I'm going to discuss two cases that involve guns, although neither of them is centered on the Second Amendment. The first case, Smith and Wesson v. Mexico, is about alleged harms to the Mexican government stemming from drug cartel violence. Question number one for the court was whether the manufacture and sale of guns is a proximate cause of cartel-related harms to Mexico. And second, did Smith and Wesson and seven other manufacturers know about illegal trafficking and thereby aid and abet the cartels? The U.S. Court of Appeals in the First Circuit held that the causal link was close enough, and the judge answered yes to the aiding and abetting question. Back in the 1980s, anti-gun activists and municipalities began filing lawsuits against gun manufacturers and dealers for crimes committed with their guns. The suits proliferated and the litigation costs were sizable. So Congress stepped in and passed the Protection of Lawful Commerce in Arms Act, which declared that no suit seeking civil damages from gun manufacturers for criminal misuse of a firearm could be brought in any federal or state court. But there was an important exception. If the manufacturer sold the gun knowing it would be used illegally, and if the sale caused injury, a suit by the injured party could go forward. Ergo, the Mexico suit against Smith and Wesson. That probably pleased advocates for gun control. But down the road, other industries, like distillers or even car companies, could also be affected, even though they sell perfectly legal products. Maybe with that in mind, Justice Kagan wrote a unanimous opinion holding that the statute bars Mexico's complaint. It's not plausible, she said, that gun manufacturers aided and abetted unlawful dealer sales to Mexican traffickers. Yes, claims are allowed when a manufacturer knowingly violates a state or federal firearms law and the violation causes injury. But here, even if the manufacturers were indifferent to trafficking, so long as they complied with the law, their conduct didn't rise to the level of pervasive and culpable assistance required for a charge of aiding and abetting. That, in my view, is the correct outcome. It brings to mind dram shop laws in some states. Imagine a barroom patron, clearly drunk, and yet the bartender continues to ply him with more liquor. The drunk then drives home and injures someone. Now, maybe a suit against the bartender is justified, but it's less obvious that the injured party should be able to sue the bar owner, and it's absurd to allow a suit against, say, Seagram's. And yet that's the equivalent of allowing a gunshot victim to sue the gun manufacturer. Our second gun-related case Bondi versus Vanderstock, was about ghost guns, which are untraceable weapons without serial numbers assembled from components or kits that you can buy online. The crux of the case did not involve the Second Amendment. Instead, the question was whether the Bureau of Alcohol, Tobacco, and Firearms correctly ruled that the 1968 Gun Control Act covered ghost guns. The purpose of that act was to help law enforcement by requiring background checks and sales records, including the documentation of serial numbers. The 1968 law defined a firearm as any device that can be readily converted to explosively expel a projectile. The Biden Justice Department pointed out that the manufacturers had advertised these kits as ridiculously easy to assemble and dummy proof. In fact, the manufacturers boasted that a functional gun could be set up in 15 minutes with no background check or serial number. The challengers responded that the ATF rule mostly affected hobbyists who just want to build their own guns. But Justice Gorsuch, joined by everyone except Thomas and Alito, disagreed. Gorsuch pointed out that some, even if not all, ghost guns did explosively expel projectiles in violation of the 1968 law. That was crucial because the challengers had argued that the law was facially invalid, meaning that it applied to all ghost guns as a class. So Gorsuch rejected their challenge, although he might have reached a different conclusion if the challenge had applied to a particular assembly kit. In any event, chalk up a win for gun control. One question the court didn't decide in the ATF gun case is whether the Constitution allows Congress to delegate its lawmaking authority to an administrative agency. But that's precisely the question raised in Federal Communications Commission versus Consumer Research. Article 1, Section 1, the very first sentence in the Constitution after the preamble, states that all legislative power is vested in Congress. Those powers are not inherent, they're delegated to Congress by the people through the Constitution. Therefore, say conservatives, Congress may not redelegate the power unless the people consent, again, through the Constitution. That's called the non-delegation principle. If Congress needs technical assistance, it can consult internal staff, universities, professional associations, think tanks, and naturally, the relevant government agency. But Congress itself should have to review the recommendations and sign on before they become effective. What have the courts said? Yes, Congress is supposed to enact legislation and not pass the buck, but governing is complicated, so we're going to make an exception. Delegation is okay as long as Congress lays down an intelligible principle to guide the agency. As a result, federal agencies now dwarf Congress when it comes to making rules that control what Americans can and cannot do. The Code of Federal Regulations containing all those rules is about 4 times as large as the United States Code containing all the laws passed by Congress. One of those laws, the Telecom Act of 1996, authorized the Federal Communications Commission to collect fees, roughly $10 billion a year, from interstate telecom companies to pay for service to neglected communities. A trade association, Consumers Research, argued that Congress's delegation of what amounts to a power to tax is impermissible. And even worse, the FCC then redelegated that authority to a nonprofit private company. The commission replied, first, the statute does set out intelligible principles to guide the agency. And second, the private company had only advisory and administrative functions, not a policy-making role. The non-delegation doctrine hasn't been applied in nearly a century. Its revitalization might have been a huge step toward removing legislative power from administrative agencies, but that's not what the court ruled. In a 6-3 opinion by Kagan, joined by the liberals plus Roberts, Kavanaugh and Barrett, the court held that the Telecom Act does contain an intelligible limiting principle, that the funds raised be enough, but no more than necessary, to ensure universal service. Yes, the amount could evolve, but it wasn't standardless. It meant, said the court, only essential, widely used services for only designated recipients. Kagan also rejected the challenge to the FCC's redelegation to a private nonprofit because the entity remained subject to the Commission's authority and surveillance. Gorsuch, joined by Thomas and Alito, dissented. They argued that the taxing power is vitally important and therefore the limiting principle must be both precisely defined and have a historical analog. Sadly, the court missed an opportunity to breathe new life into the moribund non-delegation doctrine. Okay, let's switch from administrative law to a First Amendment speech case involving social media. Free Speech Coalition versus Paxton is about content that may be harmful to kids. A Texas law requires websites that publish content with more than one-third harmful content to minors to verify the age of all users. The Fifth Circuit Court of Appeals upheld the law, rejecting a claim that it violated the First Amendment by restricting adult access to the content. In the Supreme Court, the focus was on the legal test that courts should use to determine whether the law is constitutional. The appeals court had used a test known as rational basis review, which looks at whether the law is reasonably related to a legitimate government interest. The challengers argued that the court should have used a more demanding test known as strict scrutiny, which requires that the law be narrowly tailored to a compelling government interest. I'm sure that sounds pretty arcane to most non-lawyers, but the level of scrutiny often dictates the outcome of the case. If the Supremes had insisted that the law be narrowly tailored, it probably would have been overturned on the ground that there are better ways to limit kids' access than forcing everyone to prove how old they are. In an opinion by Thomas for the six conservatives, the court held, first, that an intermediate level of judicial scrutiny applies. Intermediate scrutiny requires a substantial relationship between the law and an important government objective. So it's midway between rational basis and strict scrutiny. Second, the court said, the Texas law did survive intermediate scrutiny. Based on history and legal precedent, sexual content is considered obscene for minors. Accordingly, wrote Thomas, states can prevent kids from accessing pornography as long as the burden on adult access is only incidental. Proof of age is an appropriate means to thread that needle, like we do for alcohol, guns, and driver's licenses. Requiring adults to prove their age doesn't directly regulate their speech. But Kagan, joined by Sotomayor and Jackson, dissented, arguing, more convincingly in my view, that strict scrutiny should have applied because the law has a chilling effect on adult access. Age verification online leaves a paper trail that's more intrusive than merely showing an ID. Turning over information about yourself and your viewing habits raises the risk of leaks and blackmail. Unscrupulous websites might sell the information, or the site could be hacked or even subpoenaed. Kagan further volunteered that a properly crafted Texas law might pass muster despite strict scrutiny. Most likely, however, it'll take real-time feedback and more litigation to resolve several open questions. How will harmful to minors be defined? Will the law keep minors from accessing material that is not harmful? Do current age verification methods ensure privacy, anonymity, and security? And if not, can better methods be developed? Next, we turn to Medina versus Planned Parenthood South Atlantic, which addressed whether South Carolina can deny Medicaid funds to doctors or medical practices affiliated with an abortion clinic. Planned Parenthood and a client filed suit to restore funding of those funds. They won in the Fourth Circuit, but the Supreme Court opted to consider a procedural question whether plaintiffs can sue states in federal court to receive Medicaid dollars. Under federal law, Medicaid funds cannot ordinarily be used to provide abortions, but Planned Parenthood offers other medical services to women, including gynecological and contraceptive care, as well as screening for cancer and cholesterol. In fact, the patient went to the clinic for birth control. She argued that the Medicaid Act allows eligible patients to seek health care from any qualified provider. But South Carolina's governor responded that payment of taxpayer funds to abortion clinics for any purpose results in the subsidy of abortion, which violates federal law. Accordingly, he said, Planned Parenthood is not qualified to receive state Medicaid benefits. 70 million Americans receive Medicaid benefits, and tens of thousands of healthcare providers participate. So, resolution of this dispute has major implications. But the court faced two threshold questions. First, do organizations and patients have the right to sue states in federal court? Second, do federal laws that bar abortion funding also bar dollars to providers of other services? To prevail, Planned Parenthood had to win both the procedural battle for a right to sue and the substantive war over government dollars. Justice Gorsuch addressed only the procedural question. Writing for the six conservatives, he held that the Medicaid Act does not grant a private right to choose a particular medical provider. Yes, the law says patients can get assistance from any institution that is qualified, but if a state decides that a provider isn't qualified, neither the organization nor its patient can challenge that decision in federal courts. To allow private enforcement, a statute must use clear and unambiguous terms. Legislatures, not judges, are in control. Jackson dissented for the three liberals, arguing that when government benefits are provided, there's an implicit right to litigate issues related to receiving the benefits. That's a close call. The 11th Amendment immunizes states against most lawsuits, but Congress passed Section 1983, which allows litigation against state officials if a state violates individual rights guaranteed by the Constitution or a federal statute. This case narrows the scope of Section 1983. From my perspective, the right to sue the government when your rights are compromised is critical. On the other hand, the federal Medicaid statute has a questionable constitutional pedigree, but that is a topic for another day. Finally, an important case involving reverse discrimination. In Ames versus Ohio Department of Youth Services, the plaintiff, a straight woman, claimed she was rejected for a management job in favor of a lesbian and then demoted and replaced by a gay man. There's usually a three-step process in Title VII employment discrimination cases. First, the plaintiff must show there was discrimination based on a suspect class, such as sex preference. Let's say, for example, the department's promotions strongly favored LGBT employees, even though they were a small percentage of the workforce. If so, then second, the organization can present evidence that the real reason was not sexuality. For example, the straight lady who wasn't promoted was also frequently absent from work. But third, even if that's true, the plaintiff can try to convince the court that the organization's rationale was just a pretext. For example, the LGBT employees who were promoted had worse absentee records than the passed over straight lady. The problem in this case is that the usual process wasn't followed. Past rulings by the appellate court in the Sixth Circuit said members of the majority, that is, straight employees, had to meet an additional requirement to prove reverse discrimination. They had to provide background evidence of the organization's discriminatory intent, things like actual statements or conduct showing management's bias. That didn't sit well with the Supreme Court. Justice Ketanji Jackson wrote for a unanimous court that Title VII imposes a single evidentiary standard on all plaintiffs. She added that Title VII leaves no room for courts to impose special requirements on majority group plaintiffs alone. That holding supplements the court's recent affirmative action rulings against Harvard and the University of North Carolina, and it reinforces the case for challenging public sector DEI programs that do extend preferences to minority group members. Okay, that's my brief recap of this term's most important Supreme Court cases. Many thanks for your time and your attention.